मोसन हिसाब चाहिँ त्यही कसले छैन भनेको छैन किन त बनाइदिन्छु नि 1 2 3 होइन फेरि एक सेकेन्ड बनाइदियो गर्न 1 2 ना मोसन ना दो 30 है ना तो 30 थियो त्यो पढ्यो तर item number one return service limited return service report still kalau kecil mati itu benar apa itu
Yes, Lordship. I beg to mention item number 5, Your Lordship. The Lordship here, the respondent one, the Lordship, he's been was informed that he's been retired. So I pray that I may be granted 4 weeks time to file an implement for.
Item number 5,
Yes, Lordship.
you want to file?
Lordship,
You want to file?
I would like to file an IA for implement of respondent, since respondent one has been retired, Your Lordship.
Respondent number 1,
He's been retired.
retired.
Yes, Lordship. It's a contempt petition.
Mr. Supangwate Walling, learned counsel for the petitioner, submits that he will be filing one IA
Yes, Lord.
to implement the
Then, to implement the newly commissioner secretary, Your Lordship. As respondent 5.
commissioner and secretary.
PNR.
Secretary
Personal and Administrative Reforms Department.
as respondent number 5. Pair is accordingly allowed. List the matter on when
After 4 weeks, Your Lordship.
after 4 weeks. Okay.
Of license. Lordship, I'd like to mention item number 32, Your Lordship. It's a fixed item, Your Lordship. I've taken the consent of the other parties, Your Lordship. If this matter will be come up on this Friday, Your Lordship.
Here you are for appearing
For the petitioner, Your Lordship. Item number
petitioner
32.
32.
Yes, Lordship.
32.
Mr. Sopongwate Walling, learned counsel for the petitioner, with consent from the other side, press for listing the matter on
This Friday, Your Lordship.
Friday. Pair lot.
Obliged, Lordship.
My blessed Lordship, I beg to mention item number 9. On
Item
behalf of
number?
Motion 9.
Yes.
State is due to file it, so kindly list this matter after 1 week.
You are appearing here for the petitioner.
Lordship,
What is your name?
Pichano, on behalf of Motion,
Ms. So learned counsel appearing on behalf of
Motion,
learned counsel for the petitioner. Press for listing the matter when
after 1 week,
after 1 week.
Lordship.
Pair lot. Yes. Is
Lordship,
there any interim order?
interim order, sorry.
Yes, Lord.
There is interim order.
Yes, Lord.
Okay, till then interim order pass earlier shall continue.
And Lordship, item number 8. Lordship, I kindly list this matter after 3 weeks on behalf of Zimomi.
On behalf of
V. Zimomi.
Ms. So learned counsel appearing on behalf of Mr. B. Jimomi, learned government advocate,
Lordship,
with consent from the other side, press for listing the matter after 3 weeks.
Lordship.
Pair lot.
And Lordship, similar prayer with item number 14 and 15. Yes.
Okay, same order. 14 and 15.
In item number 14, I have instruction to appear for respondent number 3.
Okay. Mr. So-and-so, what is your name?
I, Jamir, Lordship.
I, Zamir, learned counsel for the respondent number
Respondent number 3.
3. Submits that he has the instruction to appear on behalf of respondent number 3. You have not filed your power.
No, Lordship.
And he will be filing his power on next date.
Lordship, let the matter come first week of May, Lordship.
Okay, no problem. Ask of me.
Obliged.
Lordship, I also like to mention hearing item number 27. Of visible. Kindly list this matter after 2 weeks.
20.
27.
But did you inform the other side?
Your Lordship, my senior is matter in the other courts.
Do you have any objection in
No,
that?
no.
No objection.
Lordship. Division bench matter.
Pardon?
Division bench. 27. We have a division bench.
Okay, when can it be fixed?
Thursday, no, Lordship. Yeah,
Thursday.
tomorrow.
Thursday, railway division means.
Thursday, 21st.
Lordship, after 2 weeks,
After?
2 weeks.
Yes.
Okay, so Lordship. Lordship, I beg to mention item number 19, Your Lordship. Lordship, we are going to receive affidavit in opposition from this CGSC yesterday only, Your Lordship. So only grant us 4 weeks time, Lordship, to go through the affidavits and to file reply.
You for the petitioner?
Yes, Lordship.
What is your name?
Item number 19,
What is your name?
Metovero.
Mr. Meadow Hero, learned counsel for the petitioner. Submits that the learned CGSC has filed affidavit in opposition,
Yes.
and a copy of the same is furnished to him on yesterday, and that he will go through the same and will file a reply, and therefore rise for listening the matter after
4 weeks time.
4 weeks. Here, Lord.
Lordship, there's an interim, Lordship.
Till then, interim order pass earlier shall continue.
Applies to. May I please, my lord? Lordship, I beg to mention item number 17 and 18. Lordship, I am preparing for the state respond in both these two matters.
Hmm.
If some time can be granted to me, Your Lordship, to file my counter affidavit, I have informed the other side, Your Lordship.
Okay. Mr. N. Angami,
Lordship.
learned counsel, learned government advocate. With consent from the other side, press for listening the matter after
3 weeks, my lord.
3 weeks. Is there any interim?
Yes, Your Lordship, there's an interim, Your Lordship.
Okay, till then, interim order pass earlier shall continue in both 17 and 18. Yes,
Lordship, I have a similar prayer for item number 20. Here, Your Lordship, in this item number 20, I am praying for respondent number 1.
Mr. So-and-so, learned counsel, government advocate, appearing for the respondent number 1.
My lord,
With consent from the other side, press for listening the matter after
3 weeks, my lord.
3 weeks. Madam,
Lordship, service report on respond number 2, 3, and 4 is still awaited, Your Lordship.
service report.
Yes.
So you want to take fresh step or we will await service report?
Lordship, maybe we can wait for another 3
Wait.
weeks, Lordship.
Okay. Await service report or no? Service report in respect of respondent number 2,
2,
3,
3, and 4.
2, 3, and 4 are still awaited. So await service report for the respondent number 2, 3, and 4.
Lordship.
Obliged, my lord.
With the consent of the other party, I beg to mention hearing item number 28 and 29, Your Lordship. I pray the matter may come up on Monday, Lordship.
Next Monday,
Lordship.
your good name, please.
I, Jamir.
Mr. I. Jamir, learned counsel for the petitioner. With consent from the other side, press for listening the matter on Monday. Monday is holiday.
Tuesday, Lordship. Tuesday,
Tuesday,
Lordship.
that is 26.
26th.
Okay, 26. Fair load. Is there any interim order?
No, Lordship.
No.
I'm appearing on respondent number 5, Lord. UPSC.
Respondent number. Okay. Mr. So-and-so, learned counsel appearing on behalf of appearing on behalf of respondent number 5.
Obliged, my lord.
Lordship, in item number 21, I have instruction to appear for respondent number 1.
Yes.
Please, Lords, I appear for the petitioner in item 21.
Yes, what is your pair?
I have instruction to appear for respondent number 1, Your Lordship.
Yes.
Fine.
Now, what is your pair?
I may be allowed 4 weeks time to file a power and also reply, counter affidavit to the petition.
Okay. You are Mr. Bhatnagar?
Yes, Mr. Bhatnagar is the petitioner in person. I am the counsel representing. Abhishek Goyal.
Mr. Bhatnagar, learned petitioner in person present, and Mr. I. Jamir, learned counsel appearing on behalf of respondent number 1. Praise for granting him 4 weeks time.
Lordship.
So as to file it in opposition, pair is accordingly allowed. List the matter after 4 weeks. So do we fix a date?
My lords can fix a date, plus there's also an interim order of the last date, ma'am. Continue that one.
Okay. Then suggest the date.
Um, my lords will have it on in the last week of April, lords, 23rd of April, probably.
Yes. 23rd of April. Okay, till then interim order pass earlier shall continue.
Obliged, Lordship.
Okay.
My lords, there was one more request in 21. My lords will allow us to appear virtually in this because we are from Delhi. My lords will allow us to work virtually on the next
Yes,
year.
no problem. Yes, you can appear.
Obliged, Lordship.
Okay.
Like this, Lordship. With the consent of the other party, I would like to mention item number 15 and 16. May this matter be listed.
Someone has already mentioned 15.
It is mistakenly mentioned, Lordship. These two are similar matter, 15 and 16.
Yes.
So this matter may be listed after 3 weeks.
You offered a petitioner.
Yes, sir.
Your good name, please.
Benison Bishop.
Mr. So learned counsel appearing on behalf of the petitioner. Price for listening the matter after.
3 weeks.
You inform the other side, government
Yes,
side,
yes, sir.
with consent from the other side. Price for listening the matter after 3 weeks. Here alone.
Interim order may continue.
Till then, interim order pass earlier shall continue.
Okay.
Please, my lord, item number 10,
Yes.
on behalf of MS Livika for state lordship.
Hmm.
Kindly grant 3 weeks time to file counter lordship.
Mr. So learned counsel appearing on behalf of Ms. Levika, learned government advocate. Price for listening the matter after
After 3 weeks, lordship.
after 3 weeks. So as to enable her to file
Affidavit, lordship.
affidavit in opposition. Here alone.
Lordship, similar prayer in item number 13.
Okay. Same order.
13, 1, 3, 1.
Lordship, I beg to mention item 17 and 18. Lordship, we have filed our not only today. Your Lordship
17 and
may-
18 already someone has mentioned.
Okay.
Yes. Already mentioned.
My sincere apologies. I was not aware that the matter was mentioned. However, Your Honor, there is, Lordship, there is an interim in item,
Interim will continue.
Lordship.
Okay.
Lordship, since the respondent number 6, they have accepted the notice, if this can be made, removed from the orders column, Lordship. Because it's still listed, on the last occasion, they have already appeared, given their appearance, Lordship. However, it's still in the order column, so.
You take down in 16 and 17. Miss, your good name, please.
Quickly,
Appearing on behalf of
respondent,
respondent number,
6, Lordship.
respondent number 6. Address is this, learned counsel for the petitioner submits that. Since the matter has, no, since all the respondents have entered appearance, and as such, the matter may be listed for admission hearing.
Lordship.
But she has to file his
Lord, we are yet to
affidavit in
file,
opposition.
affidavit in opposition, Your Honor.
Yes,
Time may be given, Your Lordship.
okay. Price for granting her some time to file affidavit in opposition. Here is allowed. List the matter after
3 weeks, Lord.
3 weeks. Okay. 3 weeks.
Congratulations.
So I'd like to mention item 4. It can kindly come up after 2 weeks, Lordship. I have taken the consent of the opposite counsel.
With consent from other side, Mr. Santi Anger, learned counsel for the petitioner, pays for listening the matter after 3 weeks. Here allowed.
With your blessing.
For motion, item number 1.
This is lordship. Lordship, this instant application is under section 152 of Code of Civil Procedure. praying for making correction in adjustment and order passed by this, passed by your lordship due to unintentional typographical and this clerical error, lordship. Into such judgment.
So what are the clerical mistake?
Your lordship, I'd like to take your lordship to page 9, that is lecture A, the judgment, your lordship starts from here.
No, in your application, where you have mentioned it.
Your lordship. Page 5, your lordship. Page 5, para 5. Will I read it out, your lordship? It is confused. Yeah.
So the name of the council,
The name of the council and the name of the applicant also, that is United India Insurance Company. Your lordship in page 10, your lordship of the judgment. Page 10. There is for the appellant, Fosco Forte. I was personally present on the particular day, your lordship, and I'm the panel counsel of the appellant, your lordship. And in page 11, your lordship, para 3. Being highly aggrieved, the appellant National Insurance Company, it should be a United India Insurance Company, your lordship.
no, in the application, you have mentioned it at page number 3.
No, this is from the said judgment, your lordship. That is from the said judgment. And I'm pointing out from the relevant page of my application, your lordship. Your lordship, considering the prayer will not prejudice any parties nor the merit of the
No,
case.
no, that's all right. No, you come to page number 5 of your application.
Lordship. Lordship.
This page number 2.
Your lordship, page
Oh.
number 2 of the judgment, your lordship.
Yes.
2 of the judgment, your lordship.
Hmm.
There was a for the appellant, Fosco Forte. The council for the appellant.
So in page number 2 of the judgment, where is the mistake?
In the cost title for the appellant,
Yes,
Mr. Fosco Forte.
yes.
Actually, it should be a Taiwan Chuba. I was personally present on the particular day of hearing, your lordship.
For the appellant.
For the appellant, your lordship. And I am for the appellant counsel for the appellant also.
And Mr. Forte is also the counsel for the
Assistant
United.
counsel, assistant counsel. So I am sort of, or appellant, like a impanel counsel for the impanel counsel for appellant, that is United India Insurance Fund. And I was personally present on the particular date of hearing, Your Worship. And even in Your Lordship in bed,
Is the record available, original record?
MSC appeal date of 2019.
On that day, we have a hard argument in two cases. So whether Mr. Forte appeared on the
No,
other,
Your Lordship,
other
no,
case?
on the same dates of court matter were heard. It was heard on 2011, Your Lordship, 2011 to 2023.
Hmm.
And the order was kept reserved, and Your Lordship was pleased to pronounce the judgment through PC.
Mhm.
I filed my certificate in the appeal memo also, Your Lordship.
But on the other day, Mr. Forte might have argued the matter.
Your Lordship, it is very much clearly in the videos.
Pardon?
And it was clearly, it is clearly visible in the their proceeding also, which is reported in the videos.
Videos?
Yes, Your Lordship.
Acha. Yep, I will check the video. Thereafter, I will make necessary correction.
Your Lordship.
Right. But so far, my memories goes, the other day, I have seen Mr. Forte also here.
Yeah, another matter, not this matter, Your Lordship.
Not this matter.
Not this matter. And
In
even
another-
live
other
proceeding is
matter.
recorded, Your Lordship.
Okay, I will see.
Obliged, Your Lordship.
Next item.
For motion, item number 2.
Similar, it's an overall matter,
Okay.
Lordship.
For motion, item number 30.
May I plead, Your Lordship?
Hmm.
Your Lordship, this matter pertains to dispute with regard to ancestral property of the petitioner's late father, Your Lordship. Your Lordship, the petitioner's late father was the GP of Sastami village, but unfortunately he expired in the year 1952. And leaving behind the petitioner and the petitioner's brother. But later on, the brother of the petitioner also expired while he was a minor. So in that way, the petitioner is the sole legal heir of the petitioner's late father. So Your Lordship, what happened here in this case, the petitioner's late father, while he was alive, he brought one person, namely late Haise, who is the uncle of the present respondent in the instant case. So your lordship, after the expiration of the petitioner's late father, this particular person, namely Thaise, he had occupied the GB seat of the Saptami Village Council in the pretext of to be the son of the petitioner's late father. So your lordship, accordingly, after the demise of the this late Thaise, again his brother, namely Mebise Kinimi, he managed to again become the GB of the Saptami Village Council. So again, your lordship, after the demise of this Mebise Kinimi, the present respondent in the instant case, again he tried to become the GB of the Saptami Village Council, but due to the interference of the petitioner, he could not become the GB. So that is how your lordship, there the dispute arose between the petitioner and the present respondent. So accordingly, your lordship, having left with no option, the petitioner had approached the overseas Sumi Customary Court at Junemoto regarding the ancestral property of the petitioner's late father. So accordingly, your lordship, the overseas court, Sumi Customary Court, had by order dated 2011-2021 issued direction to the Saptami Village Council to divide the properties of the petitioner's late father between the claim of the petitioner and the claim of the respondent. But your lordship, against this order of the GB's customary court, the respondent had approached district judge Junepoto before, and accordingly, the district session judge Junepoto suspended the order by order dated 2011-2021, which was passed by the overseas customary court Junepoto. Accordingly, your lordship, the petitioner again approached the learned court below sessions court, challenging the order which was suspended by the district session judge. So accordingly, your lordship, the learned court below had vacated that order which suspended the GB's customary court order. Again, your lordship, the respondent, again they filed one IA before the same London Court Sessions Court, whereby again the order which was passed by the Sessions Court was vacated, and again the previous order, that is 2011-2022, was restored. So your lordship, by that order, the main issue here in this case was, and at the same time, your lordship, while passing this order, the Honorable Sessions Court had also observed that similar matter is pending before this Honorable Court. Actually, your lordship here, yes, your lordship, that is civil revision petition number 81 of the 2022. Here, your lordship, the subject matter is that whether the district and session judge, that is civil regular court, has the jurisdiction to entertain by way of appeal against the order which was passed by the district customary court. This matter is pending before this Honorable Court, your lordship, in this matter. And in the appeal order, the court has also observed that regarding the maintainability of the appeal petition which was filed by the respondent would be considered after the outcome of this particular civil revision petition. So, your lordship, I have given many grounds, but only at this moment I would stress one particular ground. When the learned court below was very much aware that whether the Sessions Court has jurisdiction to entertain such appeal or not, which was passed by the district customary court when the matter is sub judice. At the first instance, the Sessions Court below should not have admitted the civil appeal, even though it was admitted, but should not have passed any operative order, your lordship, since the subject matter is already pending before this Honorable Court, and it was well within the knowledge of the learned Sessions Court below. So that is my prayer, your lordship. During the pendency of this suit, the appeal orders may be issued, and the notice may be sent to the respondent, your lordship.
So where you have enclosed the order dated 30th 9/2022 at page number?
85, your lordship.
Or Mr. Yogunan,
Please read, your lordship.
P.
Please read.
Learned counsel for the petitioner. In this revision petition, under section 115, read with section 151 of the Code of Criminal Procedure, the petitioner Srimati G. Kaseli Shema has challenged the correctness or otherwise of the order dated 30th 9/2022 passed by the learned district judge Zunaboto, Nagaland in civil appeal number 01 of 2022, and also the order dated 19/12/2023 passed by the district judge Zunaboto in IA number 02 of 2023 arising in civil appeal number 01 of 2022. It is to be noted here that by impugn order dated 30th 9/2022, the learned district judge Zunaboto has interfered with the order dated 28/11/2021 passed by the Dubasi Customary Court Zunaboto. And state the operation of the state order till returnable date. And what is this order dated 19/12/2023?
Yes, lordship.
This order dated 19/12/2023 at page number
103, your lordship.
And why the impugned order dated 19/12/2023, the learned district judge Juneboto has restored the original order dated 30th/9/2022. Where is the petition and the documents placed on record? Let notice issued to the respondent returnable in 4 weeks. Step be taken by registered post and also by usual process within a week from today. Call for the scanned copy of the record from the learned court below. And considering the submission of learned counsel for the petitioner and also considering the facts and circumstances on the record, the impugned orders dated 30th/9/2022 and 19/12/2023 stands state till next date. List after 4 weeks.
For admission, item number 3.
Go for the,
Sole respondent.
pardon?
Sole respondent. On
Yes,
behalf of
ma'am.
PB Fund.
None appears for the petitioner on call. However, Mr.
Withdrawal.
Learned counsel for the respondent present. List the matter after 1 week
2 weeks.
in the event of subsequent non-appearance of the petitioner. Appropriate orders shall follow.
Right.
For admission, item number 6.
Lordship, this petition has been filed for quashing of an FIR dated 30/9/2022, Lordship. The first fact of the case is that the petitioner is a businessman dealing with essential commodities. And during the business transaction, has supplied some essential commodities to the accused respondent number 1. And thereafter, sometime in the year 2022, it came to the knowledge of the petitioner that the respondent number 1 has left the state of Nagaland without paying the outstanding dues. As such, since there was no information by the private respondent, the petitioner has filed for FIR for recovery of 8,44,895. Thereafter, Lordship, on 21/10/2022, let me take you take your Lordship to the FIR first, Lordship, which is at page number 11, Lordship, of the petition. If I may read, your Lordship. Sir, I have the honor to state that I'm a businessman by profession dealing in essential commodities. And during the business transaction, I have supplied essential commodities from my firm to Shri Arun Singh, proprietor, that is respondent number 1, Lordship. party office on regular basis, and still there is an outstanding dues of rupees 8,44,895. Now that it has been learned by me that the shop owner has fled from Nagaland without paying outstanding dues for the goods sold on credit as stated above, so I kindly request your esteemed authority to kindly look into the matter and do the needful version. And may kindly punish the culprit under appropriate provisions of law, and may also kindly help me recover the dues, my dues from me. So, Your Worship, on 21/10/2022, after the private respondent has learned that we have filed one FIR, they have made a payment of rupees 3 lakhs to an account, and then on 21/11/2022, amount of 5,44,895 was again deposited. Thereafter, on 8/8/2023, Your Worship, the private respondent and the petitioner has come to a compromise that since the crux of the matter, which was recovery of the amount, have been dealt with, so the complainant would not, the petitioner would like to pursue the matter. And Your Worship, since
But the problem is that section 409 is there.
yes, sir. 409, Your Worship. 409 is in relation to criminal breach of trust by public servant or banker or merchant or agent, Your Worship. In this 409, Your Worship, there is no element of a public servant, Your Worship, which is purely between two private individuals, Your Worship. So the attraction of this one should not hamper this question of their private. I will also rely-
So whether the other side has filed any affidavit,
Yes, Your Worship.
where? Page number 16. Date of compromise.
Page number, yes, Your Worship. Compromise is at page number 16, and the relevant paragraph will be page number 17, in such, Your Worship, paragraph number 4. 17, the last line, Your Worship, that as such, on the basis of the above settlement that is followed after the agreement, the parties signs an instrument to be used in the funding SP PS case number so and so, so and so. The first party hereby withdraws his complaint against the second party and had decided not to proceed his case/charge against the second party, and as such, the first party shall be allowed to withdraw the FIR after discharging the accused second party from all the charges leveled against the second party on the basis of this compromise deed entered between the parties amicably, as neither of the
Okay,
parties shall
okay.
have.
You will put a respondent number 1.
Yes, sir.
Yes. Any objection? No objection. Pardon me, sir, your good name, please.
That could be, Your Worship.
Learned counsel for the petitioner. And Mr. M. Bhairo, learned counsel for the respondent number, and Mr. N. K. Angami, learned PP for the state respondent number 2. In this petition, come under section 482 CPC, the petitioner, Sri Arun Singh, has right for, no, the petitioner MS Northeast Marketing Company, situated at Kalibari Road, Dimapur, Nagaland, represented by Sri A. Yangar Zamir, has right for causing the FIR number SBN PS case number 0069 of 2022 under section 409 20 IPC. It is to be noted here that above noted case has been registered on the basis of an FIR lodged by Sri A. Yangar Zamir. Of Northeast Marketing Company on 30th/9/2022. The sense of allegation made in the FIR that is so and so is that by profession he is a businessman dealing with essential commodities, and he has supplied essential commodities of his farm to Sri Arun Singh, proprietor of MS Vikas store situated at Sumukidima, Nagaland, comma, the respondent number 1. And on regular basis, and there is an outstanding dues of rupees 8,44,895,095 rupees only with the said shop stroke owner. Thereafter, he came to know that the owner of the said shop paid away from Nagaland without paying his outstanding dues for the goods he has sold on credit. Upon the said FIR, the officer inserts SBNPS has registered a case being SBNPS case number 0069 of 2022 under section 409 420 IPC. And thereafter carried out investigation. At what is this? The case investigation is pending now?
Oh, Judge, there's something.
Pardon?
Still investigation is going.
And while the investigation was going on, the petitioner and the respondent number 1 entered into a compromise and also executed one deed of compromise. And on the basis of the said deed of compromise, the petitioner has approached this court by filing the present petition under section 482 for quashing the aforesaid FIR. Mr. Kondo, learned counsel for the petitioner, submits that after registration of the case, the respondent number 1 has returned the entire amount to the petitioner and thereafter executed a deed of compromise, which is enclosed with the petition as annexure number P4 at page number 16 of the petition. And as the matter has already been compromised, the petitioner is not willing to pursue the aforesaid case, and therefore it is prayed that the FIR of SBNPS case number so and so may be quashed. Mr. Bhairo, learned counsel for the petitioner, submits that respondent number 1 submits that since the matter has been compromised between the parties and the amount due to the petitioner has already been paid by the respondent, he has no objection in the event of allowing the petition. Mr. K. Angami, learned PP for the state of Nagaland, also submits that since the matter has been settled between the parties, he has no objection. The state of Nagaland has no objection in the event of quashing the FIR. Having heard the submission of learned advocates of both sides, I have carefully gone to the petition and the documents placed on record. And it appears from the annexure number 4, annexure P4 at page number 16 of the petition, especially from the paragraph number 4, that the matter has been settled between the parties. And that the parties have will have no any grievance in future in respect of the matter in issue. Further, it appears from the FIR dated 30th-9/2022 that the dispute arose between the parties out of a commercial transaction. And now the matter has been settled. In the case of state of Gyan Singh versus state of Punjab, reported in citation to Honorable Supreme Court has held that if the parties have settled the dispute, entire dispute among themselves, and if the dispute arises, if the dispute is of commercial in nature, and the parties have settled the same, then the court may allow the court may allow the court may cause the FIR. Court may cause the FIR. But while doing so, the court has to keep in mind that closing of such FIR would advance the would meet the end of justice. Here in this case, since the parties have settled the dispute amicably and no longer willing to pursue the same, this court is of the considered opinion that end of justice will be meted out if the petition is allowed, and the FIR dated so and so may be if quashed, is quashed. And since the parties have settled the matter amicably, there is no likelihood of ending the case in conviction, as the petitioner is unlikely to depose against the respondent before the court during trial. And as such, allowing further proceeding of the case would be an abuse of the process of the court. Having considered above and also considering the submission of learned advocates of both sides, this court is inclined to allow this petition. Accordingly, the petition is then allowed. The FIR of SB and PS case number 0069 of 2022 under section 409 for 20 IPC stands quashed. In terms of above, this criminal petition stands disposed of.
Much obliged.
For admission, item number 7.
So, Lordship. Lordship, on the last occasion, Lordship, this honorable court was kind enough to grant interim on 17/10/23 to the petitioner, Lordship. However, on the very day when the interim was sought, Lordship, the council could not sought for the security of the petitioner, Lordship. The type of the petitioner is has been threatened by the complainant, Lordship, and he was it's not that, Lordship, the petitioner does not want to comply with the direction of this honorable court, as well as to comply to cooperate with the investigation, Lordship. However, he could not appear, and by order dated 29/1/24, Lordship, this honorable court has cancelled the interim granted to the petitioner, Lordship. So it's my humble prayer, Lordship, that if some kind of security can be given to the petitioner to, and also interim to let him appear before the IO, Lordship.
No, the privilege of interim PRS bail was already granted to you.
Yes, Lordship.
But complying the order of the court, you failed to appear before the IO.
Yes, Lordship.
That's why the court has cancelled the
Yes, Lordship.
interim privilege of PRS bail.
Lordship,
Privilege of interim PRS bail.
yes, Lordship, we agree, Lordship. However, Lordship, we could, the life of the petitioner is at risk, Lordship. He is being threatened by the complainant, Lordship.
By
So,
the?
yes, Lordship, by the complainant, Lordship. So, and in fact, if my lord may kindly appreciate the fact that the petitioner is the owner of the vehicle, Lordship. And even the sale date that was annexed in the complaint lordship, there is no signature of the petitioner lordship. And lordship, it's not that he does not want to comply with the disorder lordship. So if my humble prayer, if some kind of interim may be given to him so that he can appear before the IA lordship. Last chance lordship. And in meantime, lordship, if necessary.
Yes, Mr. Angami, this earlier he was granted the privilege of interim PRS bail. Thereafter, by the order dated 29/1/2024, the said interim PRS bail order was recalled. Thereafter, what is this 17/10/2023 order?
Lordship, actually, my colleague, Mr. Bijmo is in the case. So, if the granting of at interim is to be reconsidered, Madam, may list the docket tomorrow so that
Day after?
tomorrow, Lordship. Tomorrow is DB because so that he can present the case, Lordship. However, if Lordship plans to pass order, I think it should not be granted. He has already he's not in the petitioner is not compliant, has not complied with the order of this honorable court, and we cannot be sure if you'll comply with even if another order is passed, Lordship. And the order of this honorable court should not be taken lightly.
Lordship, at least interim may be given lordship. And meantime, lordship. we
No,
will-
this why this order was passed 17/10/2023?
lordship. The interim was granted to the petitioner. Married lordship. Mm. I'll read the relevant part, lordship. However, in the meanwhile, considering the fact that the present petitioner appears to be the registered owner of the vehicle, which is subject matter of the FIR, he is hereby directed to appear before the investigating officer of Kohima Police Station, case number within a period of 10 days from the date of this order, and shall cooperate with the investigating officer in fair completion of investigation. And if he does so within the stipulated period of time, in the event of his arrest in connection with Kohima, he shall be allowed to go on interim bail of 30,000 rupees with one surety of like amount to the satisfaction of the arresting authority within the condition that the petitioner shall cooperate in the investigation of this case.
So by this order, you have again been granted interim PRS bail.
Lordship, after this 10 days were granted and it was fixed on 29/1, Lordship. However, Lordship, when this interim was granted, the council could not pay for the security of the petitioner, Lordship. That was, and he was scared to, it's not that he does not want to complain, Lordship, but he was scared with his life, so he was threatened, Lordship. So he could not appear, and even now, Lordship, it's not that he's ready to comply, Lordship. However, if some security can be given to him, Lordship. That's my Lordship.
So from the order dated 27/2/2024, it appears that non-bailable warrant of arrest has already been issued against you.
Yes,
But where is the question for granting you again interim PRS bail? We can finally hear and dispose of the petition. You produce the case diary.
After tomorrow or next week, since my colleague is appearing, Lordship.
Pardon, miss?
My apologies, Lordship. In that case, Lordship, if it can be fixed on the 4th of April, Lordship, so that in meantime, the main council, Lordship, is on station on his home county, Lordship. So in meantime, if necessary, we will file additional documents regarding the recent developments, Lordship, that has been taking place, Lordship.
Your good name, please?
Mikaelji, Lordship.
Heard, miss, so and so. Learned counsel for the petitioner and Mr. K. Angami, learned PP for the state respondent. The learned counsel for the petitioner submits that some kind of interim protection may be extended to the petitioner as he is being threatened by the complainant of this case, and that he is willing to comply with the order of this court dated 17/10/2023, and that he will appear before the IO and cooperate with the investigating agency. However, it appears from the order dated 29/1/2024 that the privilege of interim periods bail which was extended to the petitioner by order dated 17/10/2023 was recalled as within the stipulated period of time the petitioner has failed to appear before the IO. Further, it appears from the order dated 27/2/2024 that non-bailable warrant of arrest has already been issued against the petitioner, and the petitioner is evading arrest and is absconding. And in view of the given facts and circumstances on the record, the pair so made by the learned counsel for the petitioner cannot be acceded to. However, it is provided that the learned PP shall produce the case diary before this court on day after tomorrow, because this petition was filed long back. There is a direction of Supreme Court.
Yes.
Within a stipulated period of 3 weeks, this AB has to be disposed of. So instead of 3 weeks or more than 3 months, about 6 months elapsed.
Lordship,
Hmm.
last just with the Lordship, the council is on station.
You can argue the matter.
Lordship, he might be able to assist better. Lordship, I'm appearing on behalf of Anshuman Sharma.
Pardon?
I'm appearing on behalf of Anshuman Sharma.
That's all right. So day after tomorrow, if what is the case there, you will see. Because now we will only consider the materials in the case date. We have already heard you.
Much obliged.
For admission, item number 11.
This one. It will be enough to place an application of documents filed by the informant. for
Pardon?
withdrawal of the-
Pardon?
The informant has filed his application before the IO for withdrawal of FIR. There was a miscommunication gap between the informant and the petitioner. However, it has been settled between the informant and the petitioner. So,
Settled.
yes, Lord.
So case diary received?
So my friend would like to withdraw this in this way to bail since the matter has been settled between. the
You,
parties.
you want to withdraw this petition?
Yes, Lord.
Acha. Mr. M. Bhairo, learned counsel for the applicant, submits that the matter has already been settled between the informant and the applicant, and he has the instruction to withdraw this application. And as such, he prayed that he may be permitted to withdraw this petition. Pair is accordingly allowed this evidence disposal or withdrawal. The case will be returned if received from the concerned PS.
Obliged, Lord.
For admission, item number 12.
Then this one. Lordship, on the earlier question when petition was moved, it appears there was some confusion regarding the service of notice upon the respondents. Here there are no private respondents, Lordship. All are state respondents. The state government council has already accepted notice. Therefore, there was no necessity to serve notice upon the state respondents by way of its making, since the government council is already there. So if the petition can be served directly to the
So,
government.
Mr. Angami, you can represent all the respondent?
Yes, my colleague is, one of my colleague is here, but if there are state responses, definitely we can do that one.
So, Chief Engineer Nagaland,
Yes, yes, of course, yes. Yes, this type of other.
Yes. Heard Mr. Santi Iyengar, learned counsel for the petitioner, and also heard Mr. K. Angami, learned government advocate for the state respondents. Number 1, 2, 3, and 4. Mr. Santi Iyengar, learned counsel for the petitioner, submits that as all the respondents are government officials and being represented by the learned government advocate, no service of notice is required. And as such, the matter may be. So you have to file this affidavit in opposition.
Yes.
So when can it be fixed?
After 4 weeks, Lord.
After 4 weeks.
Send the service copy.
It can be up to 3 weeks.
So no formal notice is required to be issued. Required to be issued. And at this instance, Mr. K. Angami, learned counsel for the learned government advocate, submits that he may be granted 4 weeks time to file affidavit in opposition. Pair is allowed.
Lordship, it can kindly 2 weeks. 4 weeks is too long because this is a case of compassionate appointment. It's a simple issue. Lordship.
Compassionate appointment.
Yes, there is a standing
Okay.
memorandum.
However, pair is allowed for 3 weeks. Rest shall list the matter after 3 weeks.
If you oblige.
For admission, item number 31.
Last evening, yesterday evening,
Yes.
the AG has issued a letter. Written to the treasury officer, senior treasury officer, Long District Nagaland, Lordship. Approving the family pension of the petitioner, Lordship. Therefore, this letter may kindly be kept on the report of this honorable report as an ex Lordship and the containing petitioner clause.
You are for the petitioner.
Yes, Lordship.
Word Mr. Santi Iyengar, learned counsel for the petitioner, and Madam,
Lordship, I'm appearing for respondent number 4, the accountant general. Lordship.
learned counsel for the respondent number 4, and
I will argue for respondent number 2 and 3.
respondent number 2 and 3, and
Respondent number 1.
Mr. Angami, learned government advocate for the respondent number 1. Mr. Iyengar, producing a letter of senior account officer within bracket pension cell of the AG
Yes, sir.
dated 18/3/2024, addressed to the senior treasury officer, Longlang District, Nagaland, submits that the family pension has already, pension of the petitioner has already been settled, and as such, he is not willing to proceed with the matter, and write that the matter may be closed. In view of the learned counsels for the respondents also admits the same. In view of the submission of learned advocates of both sides, this application appears to be infructuous, and accordingly the same stands closed, and the letter dated 18/3/2024 addressed to the senior treasury officer, Longlang, Nagaland, shall be a part of record.
Noted. Thank you, sir.
For hearing item number 22.
Thank you, Mr. Lord.
Hmm.
Lordship, in coming the remarks of the biography before memory fails, he narrates about an incident that happened with him regarding a case where we are put the matter before a court, a particular judge, and by some chance the judge either retired or was transferred to another high court. Later on, we are put the same matter before another judge, and whereas he was very confident of overcoming in the earlier bench, in the next bench, his case was dismissed, Lordship. So likewise, in my instance also, Lordship, I was heard at length before one particular judge, before the trial court, appellate court, sessions court, that is. And only on the ground that the prosecution was unable to produce the property search, the seizure form, property search and seizure form memo. On that particular day, they were unable to show it in their records. The matter was adjourned. Unfortunately, the judge was transferred. After that, the matter was heard before another judge, and the judgment was returned. And unfortunately, Lordship, after a few days, the appeal was dismissed. And I have also pleaded that specifically in my petition, in my appeal memo. Some grounds, some submissions, and some decided cases which I have never placed were also produced in the judgment and order that was passed. I have also enclosed the case list of authorities that I have placed on the day the hearing was conducted. Now, Lordship, this is a case where the perfunctory and a shorty investigation was conducted. And Lordship, it is very unfortunate that there exists a very sorry state of affairs in the state of Nagaland, Lordship, where this submission is off the record, Lordship. It may not be recorded in the order. That even feel ashamed to say this, Lordship, but power of the advocates are kept in the position of the police personnel. Even to that extent, in the Tanas, Lordship. So when people are arrested, the police make an endeavor to let the accused sign the power with whom, in favor of a particular advocate with whom he has connections. So likewise, many a times the investigation is unfair, and which is why I believe also the conviction rate in the state of Nagaland is very low. Because once that is done, I believe that the investigation is also influenced and it is compromised. Now, here also, Lordship, I'll take you to the reports. The only one person, that is PW3, he actually saw the commission of the offense at 2 a.m. in the morning. He has categorically deposed before the court that he saw a fat person committing the theft. Now, I am not the fat person. Now, in the court also, when he was asked to identify, he said that the person I saw that morning, I'm unable to see him. But despite that, Lordship, I have been convicted. And Lordship, the serial memo, Lordship, it was in 2 pages. One, so the first page is the form that is available with the police. And the second page, Lordship, is a blank paper. On that, 50 items are listed. No seal, no signature, nothing. The police, as well as the witnesses. And Lordship, now there is only one accused in this case. Only I have been alleged to commit the offense. The items that they have alleged that I have stolen, it can only be carried, I believe, even the mini truck will find it difficult to be carried. Now, who steals more than he can carry? Now, Lordship, let me take my lord to the FIR first, Lordship. The case of the prosecution. Lordship, at first glance, this is such a case that at first glance, Lordship, there appears to be a strong case against the accused. But if the evidence is analyzed in detail, is properly examined, the allegation against the accused is groundless. And no prudent man with ordinary sense of reasonableness would have convicted him. And Lordship, he has already spent 9 months in prison. And because of this, Lordship, his service as a policeman was terminated. Now he has a wife to feed, kids to raise. Now, Lordship, the FIR, which I have reproduced at paragraph 2, at page 2 of my appeal memo. I may be allowed to read this.
So here you have been convicted under section 379 and 447 IPC
Yes.
for a period of
1 year.
1 year.
Yes. Lordship.
And now
Now-
1 year has already elapsed,
No,
going on.
I am out on bail this stage, Lordship. But before I availed bail from the trial court, I was in prison for 9 months. Only after 9 months, I was given bail. So during those entire period from the stage of initiating the criminal proceeding, till the conviction order originally passed by the magistrate, Lordship. After that, I prepared an appeal. That was dismissed, Lordship. So, Lordship, the actual incident happened in 2011, very bad. So during that intervening period, I was under suspension. And when the conviction was recorded, basing on that conviction order, my service was terminated. And now the situation is that unless I am already acquitted, I cannot be reinstated. Because acquittal alone, Lordship, it is settled.
No, but if the materials are there in the evidences are there against you, then how can it be?
Lordship, that is what, Lordship? Because in the FIR also 16 items are mentioned, and the FIR was not lodged by the person, Lordship,
Hmm.
present at the scene of occurrence. It was lodged on hearsay. I'll narrate the facts. 313 examination was also not properly conducted. Because it is, well, only 2 questions were asked. The law is well settled that each incriminating circumstances must be put to him distinctly and separately and specifically. And those which are not put to him, those must be eschewed from consideration. So, Lordship, in the FIR, 16 items are mentioned. This also, Lordship, a single person won't be able to carry even these 16 items. 3 bags of tea, Lordship, in the FIR, the items mentioned. 1 box of Horlicks. Now, Lordship, I'm not saying about 1 bottle. They are saying 1 box. Every day. This is milk powder. Candle 1 box. Cornflakes 1 box. Complaint 1 box. The soap 1 box. Chow, those noodles 5 boxes. Vaseline 1 dozen. Rasgulla 1 box. Surf Excel 1. Nirma powder. Tara oil 2 box. 14 refined oil 5 liter. Tea leaf gold 50 kg. Now, white magic milk. It is humanly impossible, Lordship. Well, Lordship, I'll narrate these circumstances, Lordship. The PW2, Lordship, these are sweepers. And TKL market, Lordship. I don't know if I am not aware of the market, Lordship, but TKL market is a market which is just below the port premises, Lordship. And it's a popular market. Just next to the market, there's a lake. Now, and adjacent to the market, there is the popular market. And adjacent to the market, Lordship, there were push joints, which was very popular, Lordship, those days. Now, many people, they go to those push joints, Lordship, and the vehicle road, it goes around the lake as well as the market. But there's a shortcut, Lordship, for people who travel by foot, a pedestrian shortcut, through that market, Lordship. So the petitioner, Lordship, the appellant here, he also took that road, Lordship, at around 3 in the morning. Now, Lordship, the allegation is that at 2 a.m., PW3 saw a fat person breaking into the shop. This is in the month of January, Lordship. Now, at 3:30, PW2, he reached the scene of occurrence at 3:30. That is after a gap of 90 minutes, Lordship. And it is the story of the second person who reached at 3:30 p.m. a.m. that the appellant and PW3, all of them, they sat together, they lit up a fire, a bonfire, Lordship. They sat by it They had conversation. So, Lordship, if somebody has to steal something from a particular shop by breaking open into a shop at 2 a.m. in the morning, the commission of the crime, Lordship, who would spend 90 minutes at that place of occurrence, Lordship, by making a bonfire, getting with those people from whom we have stolen. Now, in the deposition, PW2 and 3 have categorically stated that 5 plastic bags were seized from the position. Now, those are not mentioned in the FIR as well as in the decision memo, nor were to produce before the court. Now, the appellant and the witnesses, they were not formally known to each other. And when PW3 has categorically stated that we saw a fat person on that fateful morning, case identification parents should have been conducted. That was not done.
So originally the case was registered under section 457 T80 IPC,
Yes.
but a conviction was recorded under section 379 and 448.
Yes, Lord. For 380, 380 Lordship, not 379 Lordship, and 457. 380.
No, you come to the cause title of the petition. Appellant was convicted under section 379 and 447 IPC.
Yes, Lordship.
Where is the judgment in order?
The first judgment and order passed by the magistrate
Trial court.
He said, page 30, page, annexure 6. The relevant.
Page number?
30, Lordship, 30. Lordship, at page
So
39.
some mistakes are there in your cause title.
Yes, Lordship.
So unless you make necessary correction, would it be proper to hear the matter?
Lordship,
And for making correction of the cause title,
yes.
there is a procedure you have to file one I also.
Yes, Lordship. If that is my Lord's opinion, then that's fine, Lordship. But otherwise, if
He is
only for
convicted
that-
under section 457 and T80.
Yes, Lordship. I have also mentioned in my cost letter that in one, I have mentioned 379 and 457. 47,380.
Latter part is okay. This first part is,
Yes.
so you make necessary correction then. We'll hear you, we'll fix a very sorted. So how many witnesses have been examined by the trial court?
8 witnesses.
8 witnesses.
Yes. Now,
And out of 8 witnesses, how many witnesses were eyewitnesses?
only one, Lordship. The person who originally saw only PW3, Lordship. I have narrated those circumstances, Lordship, because it's like this, Lordship. PW1, he is the owner of the
Shop.
Yes, yes. So
He is not the eyewitness.
he was not the eyewitness. All the information given by him, Lordship, by those present there, he filed the FIR, Lordship. Now, PW3, he entered he was present at the place of occurrence at 2 a.m. Lordship. After that, at 3:30, PW2 reached the place of occurrence. Now, when an alarm was raised that theft is being committed, PW4 came, Lordship. Now, PW4 informed PW1 that somebody has stolen some property from the shop, and PW1 accordingly filed the FIR. Now, after that, Lordship, the rest of the witnesses are police witnesses, like the person who registered the case, the IO of the case, and arrest witness, and seizure witness.
Hmm.
So it was only PW3 who actually saw the commission of the crime at 2 a.m. in the morning, Lordship.
Hmm.
Now at 2 a.m. in the morning, he saw a fat person, Lordship.
He could not identify the person in the court.
No, no.
Then on what basis the court below has recorded?
Yes, that is what, Lordship. And
Mr. Angami, have you gone through the record?
Yes, yes. What I hear, actually, here the seized item were recovered from the possession of the convict.
Hmm.
So the chain of witnessing, then the recovery of
No,
the
at which place? From the place of occurrence?
nearby the place, about 200 feet.
no, Lordship, it's false, Lordship, because there are big shops there. It's a market, Lordship. So whatever goods were there in the shop, they have listed everything, Lordship. Randomly.
No, but if it is just random like that, you'll never be seized, it will remain in the shop. You were in the seizure memos, will release to the rightful owner. So something's not, I don't think convict is a very good case as far as all these chains of circumstances and evidences are concerned. 2, 3,
And an item is listed in the seizure list, it does not mean that theft has not come with, Lordship. Because somebody may also make a false allegation, Lordship, and then there are 50
but those
items.
are not raised in the trial stage.
Hmm.
Now, Lordship, there are an appellate court, Lordship, it is well settled, Lordship. Can
Reappreciate the evidence.
reappreciate the evidence. Yes, Lordship.
Now, only if it is acquittal. There is not a question of acquittal.
No, Lordship, there is no such.
No, even then, even conviction is recorded, the appellate court is to appreciate the evidence.
Now, Lordship, even on the date of, this is what, Lordship, this is important, Lordship. When it was heard before the other session starts, Lordship, who was later transferred, on that day, the prosecution was unable to place on record the, it was not on the record of the court, Lordship, the seizure memo. Now, only when the matter was heard on 18/3/2020,
Hmm.
on that day only, the seizure memo was placed by the prosecution, Lordship. That also on a piece of paper.
No, whether that was exhibited in the court, then how can the court take
Yes,
into
that's not,
account?
Lordship. And that also before the appellate court, not before the original trial court. And Lordship will kindly appreciate that there were only 2 questions Lordship were asked to me during examination. And Lordship is very well aware that each incriminating
No,
circumstance.
that's all right. That is settled question.
Yes, Lordship.
Okay, you make the necessary correction then. We'll list the matter next week or this week.
Lordship, next week, I have difficulty, Lordship. If not, this week after 2 weeks, Lordship.
After 2 weeks. Okay, as you like.
Lordship, let's try next week.
Lord, next week I have difficulty, Lordship, even if it is listed. So I have a humble apology, but
Heard Mr. Sanjay Iyengar, learned counsel for the petitioner, and Mr. K. Angami, learned counsel for the respondent. No, learned PP for the state respondent. Heard in part, list the matter on suggest on that.
Lordship, if you can be kept as partner,
Yes.
then my learned friend
after the,
with the death.
what my lords, whether my lords will be around after 2 weeks.
When?
After 2 weeks, next week I have a difficulty.
After 2 weeks.
Yes, Lordship.
But I will not be here
Yeah,
after
that
2 weeks,
is,
and then
If it is to be kept as partner,
it will be
whether-
difficult for others also to hear the matter.
Lordship, we can try next week, Lordship.
next week I have a difficulty, Lordship. I'm going out.
Okay, then 26.
Because Lordship, this is pending since 2020.
Yes.
Lordship, this week next week I have a difficulty, Lordship.
Pardon?
Next week I have difficulty to come to court.
Then on Friday?
22.
Yes.
Okay, 22. In the meantime, Mr. Sanjay Iyengar, learned counsel for the petitioner, shall take necessary step for correction of the cause title.
For hearing item numbers 23 to 26.
But the other side?
On last occasion, they informed the court that they were filing power
Hmm.
on several occasions, but I think on the last occasion, this honorable court has given last chance.
Hmm. Last opportunity is accorded. What to do?
I think it's after 3 weeks, I think last.
After
3 weeks.
3 weeks.
Yeah. Interesting, that is.
Lordship, my sincere apologies, Lordship. In the other case, Lordship, if I may kindly be allowed to make photocopies of the LCR,
Photocopy?
of the lower court reports, Lordship, so that I'll be able to assist my Lord better on the date of hearing.
You can go through it.
My Lord.
It is available in the court.
Yes, Lordship.
Yes, you
If it
can.
can be reflected in the order.
Okay, Mr. Sanjay Iyengar, learned counsel for the petitioner submits that he may be permitted to go to the record of the learned court below.
My Lord.
Here, look.
Deeply obliged.
Mr. Tayong Subba, learned counsel for the appellant present, but none appears for the respondent on call. Recessal is the matter after
3 weeks.
3 weeks. So in all these matters,
I don't know what's happening. Your motion.
For hearing item number 33.
The part that made yesterday.
yesterday, yes.
Which one to place the judgment, which was directed to that from the place.
Yes. So the only issue was how to determine this disability.
Your
Lordship. That was the question on the other.
Online Supreme Court, Your Lordship.
So what is the relevant paragraph?
I would like to take Your Lordship to page number 349. Para number 9, Your Lordship. Shall I read it out, Your Lordship?
Yes.
The percentage of permanent disability is expressed by the doctor with reference to the whole body or more often than not, with reference to a particular limb. When the disability certificate states that the injured has suffered permanent disability to an extent of 45% of the lower limb, it is not the same as 45 permanent disability with reference to the whole body. The extent of disability of a limb or part of the body expressed in terms of the percentage of the total functions of that limb obviously cannot be assumed to be the extent of disability of the whole body. If there is 60% permanent disability of the
No,
right.
you come from this paragraph number 8,
Lordship.
because assessment of
Assessment,
future
Lordship.
loss of earning due to permanent disability.
Para eight, Lordship.
Yes.
Disability refers to any restriction or lack of ability to perform an activity in the manner considered normal for human being. Permanent disability refers to a residuary incapacity or loss of use of some part of the body found existing at the end of the period of treatment and recuperation after achieving the maximum bodily improvement or recovery, which is likely to remain for the remainder life of the injured. Temporary disability refers to the incapacity or loss of use of some parts of the body on account of the injury, which will cease to exist at the end of the period of treatment and recuperation. Permanent disability can be either partial or total. Partial permanent disability refers to a person's inability to perform all the duties and bodily function that he could perform before accident. Though he is able to perform some of them and is still able to engage in some gainful activity. Total permanent disability refers to a person inability to perform any avocation of employment related activities as such of the accident, as a result of the accident. The permanent disability that may arise from motor accident injuries are of a wider range when compared to a physical disability, which are enumerated in the person with disability. So and so this regarding disability, Your Lordship. Para 10, Your Lordship. Where the claimant suffers a permanent disability as a result of injuries, the assessment of compensation under the head of loss of future earning would depend upon the effect and impact of such permanent disability on his earning capacity. The tribunal should not mechanically apply the percentage of a permanent disability as a percentage of economic loss or loss of earning capacity. In most of the cases, the percentage of the economic loss, that is, the percentage of loss of earning capacity arising from a permanent disability will be different from the percentage of a permanent disability. Some tribunals wrongly assume that in all cases, a particular extent percentage of permanent disability would result in a corresponding loss of earning capacity, and consequently, if the evidence produced shows 45% as the permanent disability, will hold that there is 45 loss of future earning capacity. In most of the cases, equating the extent, the percentage of loss of the earning capacity to the extent percentage of permanent disability will result in the award of either too low or too high a compensation. Your Lordship, the relevant portion again. In page number 351. Para number 16. Para 16. The tribunal should not be a silent spectator when a medical evidence is tendered in regard to the injuries and their effect, in particularly the extent of a permanent disability. Section 168 and 169 of the Act make it evident that
tribunal does not function as a neutral umpire as in a civil suit, but as an active explorer and seeker of the truth who is required to hold an inquiry into the claim for determining the just compensation. The tribunal should therefore take an active role to ascertain the true and correct position so that it can assess the just compensation. Your Lordship, paragraph 17, Your Lordship. If a doctor gives evidence, uses technical medical terms, the tribunal should instruct him to state in addition in simple non-medical terms the nature and the effect of the injury. If a doctor gives evidence about percentage of permanent disability, the tribunal has to seek clarification as to whether such percentage of disability is a functional disability with reference to the whole body or whether it is only with reference to a limb. If the percentage of permanent disability is stated with reference to a limb, the tribunal will have to seek the doctor's opinion as to whether it is possible to deduce the corresponding functional permanent disability with reference to the whole body, and if so, the percentage. Paragraph 18, Your Lordship, this is very important. The tribunal should also act as a caution if it is proposed to accept the expert evidence of doctors who did not treat the injured, but who were ready to use it, disability certificate, without proper medical assessment. There are several instances of unscrupulous doctors who, without treating the injured, readily give liberal disability certificate to help the claimant. But where the disability certificate are given by the duly constituted medical board, they may be accepted subject to evidence regarding the genuineness of the certificate. The tribunal may invariably make it a point to require the evidence of a doctor who treated the injured or who assessed the permanent disability. Mere production of a disability certificate or discharge certificate will not be a proof to the extent of disability stated therein, unless the doctor who treated the claimant who medically examined and assessed the extent of disability of the claimant is tendered for cross-examination without reference to the certificate. If the tribunal is not satisfied with the medical evidences produced by the claimant, it can constitute a medical board from a panel maintained by the consultation with reputed local hospital, medical colleges, and refer the claimant to such medical board for assessment of the disability. Your Lord, my Lordship, in my case, Your Lordship, the claimant was treated at government hospital, Your Lordship. Assam Medical College, I will take Your Lordship to page 19, Your Lordship, of my appeal memo. Yes. That paragraph, Your Lordship. Shall I read it out, Your Lordship? Page 19, third paragraph.
Yes.
The claimant has stated that the pleading as well as in the position that on so and so the pickup train was going for Badan side and so, coming from opposite direction, driven in rash and negligent manner, blocked the accident. In the accident, the claimant who was a hire of the aforesaid pickup prevailing registration number so and so sustained multiple injuries over his person with fracture, shaft, forearm. Medical certificate are exhibited as so and so. Exhibit 4, P4, P5, P6 is the discharge certificate from the Assam Medical College Hospital, Tripura, Assam. This is also one of the in deposition and exhibits. And Your Lordship, Your Lordship, page 17, Your Lordship.
Of your memo of appeal?
Yeah, or memo of appeal, page 17.
Yes.
Family members and myself, exhibit P1 is the claim petition filed by me, exhibit P1 is my signature, exhibit P1 is the police report in the MVA report, exhibit P4 is the discharge slip issued by the KK Civil Hospital, Kolkata, exhibit 5 is the injury report issued by KK Civil Hospital, Kolkata, and exhibit P6 is the discharge certificate issued by Assam Medical College Hospital, Tribunal, Assam, Your Lordship. Lordship, the tribunal below, in the issue number 6, Your Lordship, that is page number 21, Your Lordship. In reference to the disability. Can I read it out, Your Lordship? Issue number 6. Whether the claimant has suffered permanent disability and entitled to any compensation, if so, what extent and payable by whom? As discussed in issue number 1, 2, 3, 4, 5, stands duly decided in favor of the claimant. This issue is also decided in favor of the claimant. Lordship, the tribunal has not went to the depth of the search of this disability, Lordship, but just by placing the report before the tribunal has considered the disability certificate. And moreover, Lordship, the disability certificate is issued by the other doctor.
Let us see the exhibit P16.
Report, Lordship. The additional documents filed by the claimant.
So this is not issued by the disability board.
No, Your Lordship. One of the private doctor, and who has not even treated the injured claimant also. There was no medical report in support of that.
Lordship, actually, the doctor has treated. Lordship, actually, after the accident, the claimant, that now the disease was taken to KK Hospital, Kolhagat. However, seeing the grievous nature of injury sustained by him, he was referred to Assam Medical College, Dibrugarh, and he was there for about 11 days at Assam Medical College, Dibrugarh. However, the attendance of the disease, they requested as from Sukhadar to Dibrugarh, long distance, hence requested for discharge, and he was discharged on request. And after that, he was brought to his hometown and he was treated by the local doctor of this Bogatan government CSC, that is a government hospital. He was a government doctor. He's a government doctor, Lordship. And there are some restrictions and case memos too. He was treated by that doctor. He is not a private doctor.
So whatever may be by this medical board has to be constituted in order to stand for this evidence.
Lordship, now he is no more.
The tribunal would have constituted.
Actually, my lord, let me submit little in this respect. That is there, of course. But it is also the insurance company at the time when the documents was exhibited, marked. They did did not protest while exhibiting. Okay, Thereafter, the insurance company never prayed or have filed a petition before the tribunal below to examine or cross-examine the doctor. That means it is somewhat like giving consent. And now at this honorable appellate court, they are challenging. This is also one point to be taken into account, Lordship.
No, that's all right, but the question is whether it was determined in accordance with law or not. That is the question.
Of course, Lordship.
Mm.
No, the Lordship may pass any order has deemed fit and proper. No, I have nothing to say.
Lordship, in the apex court,
I live upon this honorable court.
even the apex court in the same judgment, which have read, Lordship has said mere production of certificate. will not- Even, insurer has raised the objection before a trial court.
No, Mr. Secretary, you say, had this certificate been issued by a medical board, even then we would have accepted it, you see. But this doctor, 30% disability, whether disability is there are disability may be permanent and disability may be temporary also, whether it is temporary disability or permanent disability.
I do agree, but the thing is that it is also the fault of the insurer.
No,
They did not challenge.
Mr. Secretary, you see, it is the primary duty of the claimant, no, to.
Lordship, it is there also. So I live upon this honorable court. I have no more substance.
Okay, we will see what to do.
As the original claimant is also no more, and he is survived by his wife and 3 children.
I heard Mr. Tayong Subba, learned counsel for the appellant, and Mr. P.B. Setri, learned counsel for the respondent. Argument concluded, order is it.
My please, Lordship. Lordship, my apologies, Lordship, but in item number 3, where the petitioner was absent, I was informed that this matter was wrongly listed today, Lordship. It was supposed to come up on 19th of April. So the petitioners still were not aware of the matter listed today.
This one?
On 19 April.
Yeah, on that day you pointed out to the court. Today we have already passed the order. You pointed out to the court on that day. That this case has wrongly been listed today.
이구나. 나 보지. 무슨 사도 이쪽으로 나오지. 나비 무비 체크 보시 19 나도. 무비 나. 무비 22 나게 보시. 예. ini segini ini dah terus. Movie jika costly 1914 movie na itu sebenarnya itu kita tidak tahu within 3 weeks lah I'm there ini ada list untuk masuk di mana nanti pun mau kau di na 19 days areas na adjustment reserve. itu tuh just for the job. Mana just due to the what kita lalu itu pas punya jam. Item number 1 aku dah. You know. Siri. Bukan. Wah.
Ini short versi akan confuse makanya.
Sapi. Ini si Siri. Buru nak bagaimana ini? Tadi lihat ni. Court sih deh.